सेठ जी,
जी।
ऐसा है जी, जुर्म सोचने के लिए सजा नहीं मिलती, जुर्म करने के लिए मिलती है।
Under the Indian Penal Code, an offence is punishable when it is actually committed. But let's take a situation. Let's say a group of persons plan to blast bombs in a city. These persons were arrested in police raid, and police recovers RDX from these persons which they were planning to use to make bombs. Now, is it legal for police to arrest a person for something which they have not yet committed? Can law punish someone for an offence before it is even committed? The answer is yes. A person can be punished for an offence not just for committing it, but also for making preparations for committing the offence. This is covered under Section 120A. Section 120A deals with criminal conspiracy. Let's understand this offence in some detail now. The word conspiracy means a secret plan or agreement by a group of people to do something bad or illegal. So to convict someone of criminal conspiracy, the following conditions must be fulfilled. First condition: there should be an agreement between two or more persons. This means a person cannot conspire by himself. There must be more than one person. Second, the agreement must be to do or cause to be done any illegal act, or to do a legal act by illegal means. This means there must be a joint evil intention among the conspirators to commit an illegal act or a legal act by illegal means. Third condition: apart from agreement to commit an illegal act, there must also be some other act done by one or more parties to such agreement to execute such plan or agreement. Now, what is the logic of this condition? See, proving someone's intention is a very difficult job. People say so many things in fun or in a lighter way, but that doesn't mean that they really intend to do it. For example, two persons agree to kill a third person. Now, how to know that their intention is serious? But if these two persons try to contact a contract killer, then this proves that their intention to kill is serious. They actually want to do that, and they can be booked for criminal conspiracy. Alright, so if these three conditions are fulfilled, a person can be convicted for criminal conspiracy. Let's understand it through some examples. First, Mr. A and Mr. B plan to kill Mr. C. Do you think it will amount to criminal conspiracy? Not yet, because condition number 3 is missing. It is not enough to convict the person simply because they have agreed to do something illegal. There must be some other act in preparation of executing the illegal act, which they have agreed to commit. Now let's change the example a bit. Mr. A and Mr. B plan to kill Mr. C, and for this purpose, they procured a pistol to shoot Mr. C. Now this becomes criminal conspiracy as all the three conditions are now fulfilled. Second example. Mr. A and Mr. B hire Mr. D to kill Mr. C. It is again criminal conspiracy because even though they did not plan to kill Mr. C by themselves, they are causing it to be done by a third person. Also, hiring Mr. D to kill Mr. C fulfills condition number 3, which talks about doing some other act in pursuance of the committing intended illegal act. Third example. Mr. A and Mr. B lent some money to Mr. C as loan. Mr. C promised to repay the loan after 3 months. However, after 3 months, Mr. C refused to repay the money. In order to get their money back and to teach Mr. C a lesson, Mr. A and Mr. B planned to physically assault Mr. C by hiring some goons. Here, Mr. A and Mr. B has a right to get their money back. It is a legal act, but the way they are trying to get their money back is illegal. So, even this act will amount to criminal conspiracy. Now, Section 120A also has an explanation appended to it. This explanation says it is immaterial whether the illegal act is the ultimate object of such agreement or is merely incidental to that object. Let's understand this through an example. a group of persons plan to kidnap a politician. The politician always walks with his 2 bodyguards. Now this group of persons make a plan to kill the 2 bodyguards so that after killing the bodyguards they can kidnap the politician easily. For this purpose they arrange some weapons also. Now this will still amount to criminal conspiracy. Here the ultimate object of conspirators was to kidnap the politician and not to kill the bodyguards. But it is immaterial here. The conspirators will still be guilty for criminal conspiracy. Now let's look at some important points relating to criminal conspiracy flowing from various judgments of the courts. First, only the intention to commit crime along with some overt act is necessary to hold a person guilty under section 120B. Actual commission of crime or attempt to commit the crime is not necessary. Second, the illegal act does not mean only criminal acts. It may also include civil wrongs such as civil trespass. Third, although to constitute the offence of criminal conspiracy, involvement of at least 2 or more persons is necessary. However, only a single person may be convicted if the other persons are either unknown, uncaught, dead, incapable of committing the crime, such as minors or persons of unsound mind, or if the persons have immunity against conviction, or if they have been pardoned. Fourth, it is not necessary that every conspirator should take active part in committing the offence. The very fact that such conspirator agreed to do something illegal is enough to convict him. Fifth, agreement to commit illegal act may be express or implied. Sixth, it is not necessary that a conspirator knows all the details of the plan and be an active participant at every stage of such plan. He will still be guilty. Okay. So this was all about criminal conspiracy. Let's look at the punishment for criminal conspiracy, which is covered under section 120B. Section 120B prescribes punishment for criminal conspiracy. Now section 120A basically says any agreement to do any illegal act is criminal conspiracy if it is coupled with some other act in pursuance of such conspiracy. Now illegal acts can be of many types. Anything against law is illegal, but all illegal acts are not serious. For example, if you jump a red light, it is illegal, but it is not that serious. So as some illegal acts are serious and some are not, it would have been improper to punish everyone with the same quantum of punishment. This is why section 120B divided punishment into 2 parts. The first part talks about punishment for bigger illegal acts. The second part talks about punishment for not so big illegal acts. So according to part 1, if the conspirators conspired to commit an offence which is punishable with death or life imprisonment or with rigorous imprisonment of 2 years or more, and where no express provision is made in the IPC for punishment of such a conspiracy, then such conspirator will be punished in the same manner as if he had abetted such offence. So for this we will have to look into section 115 to 120, which deals with punishment for abatement. Okay. Now if we look at the second part of section 120B, it says if the conspirators conspire to commit an offence which is not covered under part 1, then punishment will be imprisonment of either description for a term not exceeding 6 months, or with fine, or with both.